Hi, hello, and welcome to my channel, friends. This is your Govindraj. Thank you very much for your trust and support. As I indicated in my previous video, I have designed a detailed module on prevention and redressal of sexual harassment of women at workplace, and this program has got a duration of 4 hours. And as you know already, the employers and the managers who are responsible to run the business have an important responsibility at the workplace to protect the rights and interests and also keep up the dignity of women at workplace. So therefore it is important for all these people to know the requirements of the law and take care accordingly. So I'm going to give you certain highlights of this detailed program in this video. So this program is available in a platform called virtualhrpartner.com. I've also given the link of this program in the description box of this video, and you can all make use of this opportunity and take this program for benefit of everyone. And I'm sure this is going to benefit and also give you a lot of knowledge enhancement on this topic. So this module is divided into 5 chapters for the convenient and understanding purpose. The chapter 1 talks about genesis and basics on this topic. Chapter 2 talks about committees and various other authorities under the Act. And chapter 3 talks about complaints of sexual harassment and conciliation. And chapter 4 deals with enquiry and relief. And the final chapter 5, which is talks about other key provisions and few case studies. Let me give you some of the salient or the key features of the law so that it describes the importance and also sensitivity of this topic. See, the law has the objective of protecting women at workplace from sexual harassment, and the workplace definition has been defined in such a way to include even dwelling houses. If you look at the law, section 2N of the Act defines sexual harassment, and this is the same definition which is the Honorable Apex Court or the Supreme Court of India gave the definition in the case of Vishaka and others versus Rajasthan. So let me read it for you once again. Sexual harassment includes any one or more of the following: unwelcome acts or behavior, quote unquote, unwelcome acts or behavior, whether directly or by implication, even if it is implied, that is also construed as sexual harassment. In the case of sexual harassment, workplace sexual harassment should be sexual, unwelcome, and the experience is subjective. As I said, this is a very sensitive and subjective case. And here the impact matters and not the intent. Now let's understand certain situations whether they qualify as sexual harassment or not. Feedback on performance, particularly when the manager is required to give development inputs or lower ratings based on the actual performance. Welcome to the second module on prevention and redressal of sexual harassment at workplace. And also note this, it is obligatory on the part of employer to implement the recommendations of the IC, whether it can be interim recommendations or final recommendations, and also send the report to internal committee on such actions. This responsibility is provided under section 12.3 and 13.4 of the Act. So not only fulfilling the recommendations of the internal committee or the final recommendations, if there are any internal recommendations, he is also required to take action, and also he should communicate to the internal committee what actions have been taken. And the recommendations of the internal committee, there is a time limit to comply also by the employer. These recommendations have to be acted upon by the employer within 60 days from the receipt of such report or recommendation. So and there is another member is required, one external member, either from an NGO committed to the cause of women or a person familiar with the issues relating to sexual harassment. So that this kind of external member to be nominated to the internal committee, and this responsibility is fixed under section 4.2c of the Act. So let's also talk about powers under section 11. So this section 11, as I said, this is related to inquiry, and inquiry needs lot of powers for summoning the evidence, summoning the witnesses and other things. Therefore, the LC shall have the powers of a civil court when trying a suit in respect of certain matters. And welcome to the third module. Now let's take a first question, which is very basic. What is the complaint of sexual harassment? Because it is required to understand what constitute or what is the complaint of sexual harassment. See, it is a written representation by the aggrieved woman who is sexually harassed at workplace. So therefore, you can look at this. It is a written representation by the aggrieved woman. Now, to whom the complaint has to be submitted? So we already talked about internal committee, local committee. So now it is also important for us to understand to whom the complaint has to be submitted. See, the complaint should be filed to the internal committee if the aggrieved woman is an employee in an establishment where the internal committee is constituted. So let's take another very important question related to this. Can the complaint be sent to the HR department or the human resource department or any other senior officer or managing director or employer of the company? Now, what are the other necessary ingredients of a complaint? Are there any other criteria or any other necessary ingredients to be taken care or necessary precautions to be taken care while making a complaint? Conciliation and settlement. See, the law also provides for conciliation and settlement in case of sexual harassment cases. So, a very important question. What if the terms of the settlements are violated? Sometimes the parties agree and they come to certain understanding, and more importantly, the respondent agree for certain compliance of certain terms. What if those terms are violated? Welcome to this fourth module. And this module is very important because it is related to inquiry of sexual harassment complaints and also the relief and actions. So therefore this module is very important. Now let's look into what is inquiry. See, we need to understand first of all what is inquiry. Now, who has to initiate the inquiry? This is very important to understand, because if you look at the scope of the act, there are two committees. One is the internal committee, the other one is the local committee. Now let's understand, how about when the respondent is an outsider, or for example like a visitor or supplier or vendor who comes to workplace and harass any woman employee. Now let's understand what is the inquiry procedure, because when you conduct an inquiry, so what is the procedure to be followed is important step of the inquiry. And if you look at the scope of the act, there are certain provisions are provided which we need to understand. Let's understand what are the principles to be followed, and we will also understand what is the procedure to be followed during the inquiry, and we will understand what are the principles to be followed so that the inquiry is transparent and accurate. Because we have seen many cases that the inquiry is not conducted properly and the respondent ultimately gets escaped because of the procedural related issues in the inquiry. So going ahead, friends, we also have to understand how to ensure the adherence of principles of natural justice in the inquiry. So I talked about inquiry should necessarily be guided by the principles of natural justice. Entire process from the submission of the complaint, from taking an action by the employer, this entire process should be guided by the principles of natural justice. The place of inquiry also matters. This place of inquiry should not be very far away from the place of workplace. Notice of hearing is also very important, and that too, the notice of first meeting is very important. Now let's understand, we talked about the internal committee or the local committee has the powers of civil court in the case of enforcing the attendance of a person as witness and also requiring to produce the documents or records. How these powers can be invoked, because it's an internal process, it's an internal inquiry. How can this process or how can these powers can be invoked? Now we will also need to discuss about about the inquiry report. So we talked about certain principles to be followed and the provisions to be followed. So we need to know what needs to be taken care while writing the inquiry report. Section 13 of the Act and Rule 9 of the Central Rules talks about inquiry report and actions after the inquiry. So we will also talk about the report and the further process. Welcome to this final fifth module on this topic, and this topic is very important and also has got high significance because it is the responsibility of every employer and every manager, every supervisor to make sure that there are no sexual harassment complaints at workplace and the dignity and the interests of the women employees are protected at the workplace. Even if there are sexual harassment complaints, there should be an effective machinery to deal with such complaints and redressal of complaints. Now let's recap all these timelines and limitations provided under the Act for our quick reference and proper understanding. See, if we talk about submission of complaints by the aggrieved women under Section 9(1) of the Act, the complaints should be submitted within 3 months from the date of incident. If there are series of incidents, and within 3 months from the last incident, the complaint should be filed. And going ahead, friends, let's understand the important matter on this topic which is confidentiality in sexual harassment cases. And let's take another important connected question on this. How about the information if anybody requests under the Right to Information Act 2005? How to deal with false or malicious complaints or false evidence? We have seen also, we have come across some of the employees also file certain false or malicious complaints, and the witnesses also provide certain false evidence or forged documents, and it is also an offense under the Act. Let's understand there is another important requirement of submitting annual report. Now let's understand the detailed requirement of annual report by the internal committee as well as the employer. We have covered the key and major provisions of the Act. Now we will look into certain cases of certain examples of cases which amounts to sexual harassment. You can read these cases and understand for your information. We also need to know certain type of cases may not amount to sexual harassment. So we need to also understand these dynamics. I have given some of the examples which does not or which may not amount to sexual harassment. You may read these cases and understand for your information and knowledge purpose. I am sure these modules have enhanced your knowledge, and I would request all of you to recommend this module to all others in your contacts, and also you can send your feedback to my email ID which is 3lrpartner@gmail.com, and if you like it you can also send your feedback to the platform email ID which is info@virtualhrpartner.com. So friends, thank you for watching my e-learning modules which are spread out to 5 modules, and as I said, this is very important and critical topic for all employers, managers and supervisors who are responsible for this activity. If you have any clarifications, you can also get in touch with me over my email, and depending upon my timelines, I will be happy to respond to you. And thank you for watching this video, and see you soon, friends.